proceeding. Good afternoon.
Good afternoon, Your Honor. Brett Nave of Latham & Watkins on behalf of the debtors. Today's agenda was originally filed at docket number 184 with an amended agenda filed at docket number 193. It's that agenda at docket number 193 that I'll refer to today. I'm joined in the courtroom this afternoon by our colleagues at Young Conaway, the debtor's chief restructuring officer, Justin Pugh of FTI Consulting, who is present, Ophir Nitzan of Guggenheim Securities, the debtor's proposed investment banker, who is also present in the courtroom. Also from Guggenheim, Morgan Sakow is participating via Zoom, and my colleagues from Latham & Watkins, Caroline Reckler and Christopher Harris, who will be handling certain aspects of today's hearing, are also present in the courtroom. And also from Latham, George Davis is participating through Zoom.
Okay.
Your Honor, I want to start by thanking you and your chambers for accommodating us today and for entering the orders on the Young Conaway and Omni retention applications before the hearing. The remaining items on the agenda for today are Guggenheim's retention application, which is item number 3 on the agenda, Latham & Watkins retention application, which is item number 4, the retention application of FTI, which is item number 5, the bidding procedures motion, which is item number 6, and finally the motion to approve the settlement with PJM, which can be found at item number 7. If acceptable to Your Honor, we propose to take those in order.
I'd like to get an update, if I can, on where things are, and particularly I know that indications of interest were due on the 10th, I believe. I'd like to get a general update.
Sure. We received several indications of interest in that process, and we have folks who have submitted indications of interest, are continuing to due diligence. They're working in a data room as we speak, which has been populated with information. We are continuing to engage and answer questions through Guggenheim as investment banker, and we look forward to continuing that process and are hopeful that we will receive one or more bids by our bid deadline.
Okay. And can you tell me, I guess because it's not totally clear to me from reading what's been filed, that sort of the timeline between the sale process and the plan process.
Yes, Your Honor. The way we envision those dovetailing is that we have the deadline set forth in the bid procedures order, which I believe is a June 20th bid deadline, with a then disclosure statement hearing on June 21st. And then our auction, I believe, is several days after that, and then a confirmation hearing would be in late July, and I'm flipping to the exact dates here. Yeah, a confirmation hearing would be July 26th. The way we envision this occur...
Where are those set out?
Those would be in our disclosure statement motion.
Which hasn't been filed,
It has
right?
It has been filed. I believe it is... I can find the exact docket reference to that, but the disclosure statement motion was filed on, I believe, about a couple weeks back now.
Oh, okay. I don't have my calendar. Okay. So the disclosure statement has been filed.
The disclosure statement has been filed, a proposed plan has been filed, and the disclosure statement motion has been filed. The dates, again, we're proposing we would have a bid deadline of June 20th, disclosure statement hearing of June 21st, then confirmation, the proposed date we have penciled is July 26th, and the way we're envisioning the sale process dovetailing with confirmation is that we would have our auction, and by that point we would have our successful and backup bidders if the auction goes forward, and we would propose to have those sales approved as part of confirmation of the plan. And our confirmation order would double as a order approving the sales and an order approving our plan.
Okay, and if there is no purchaser, then the backup to that is that the pre-petition lenders end
Yeah.
up with the equity?
That's exactly right. In the plan is baked in the treatment of the pre-petition lenders is that they will receive the cash proceeds of a third-party sale up to the amount of their secured claim. Or if there is no third-party purchaser, they will receive equity in a vehicle that will purchase the assets effectively through a credit bid.
They will receive equity in an entity that will purchase the assets.
It will,
Okay.
yes.
And so what happens to the debtor?
The debtor would be wound down as part of a wind down process under the plan.
Okay, so the settlement agreement, then in that context, the purchaser who PJM would be dealing with is either a third-party purchaser or it's this new lender entity.
That's exactly right. And that was a critical issue for PJM in the settlement negotiations is that it be an asset sale. So there is, for purposes, as I understand it, of their tariff and operating rules, which they would buy with FERC, that there needed to be a asset sale as opposed to a continuation of entity.
Okay, and what's the treatment of unsecured creditors under the plan?
Right now, there is a contemplated distribution to unsecured creditors of a set amount. That amount is TBD and still subject to negotiation with our secured lenders, which we are hopeful and fully intend to fill in advance of disclosure statement hearing.
Okay, I wondered because I noticed in the, I guess in the term sheet, with, let me get this down, with PJM, that the amount of any duck pool was not set yet.
That's correct.
So I guess I was a little surprised. I guess I just didn't realize that the plan and the disclosure statement had already been filed, and that didn't lead me to believe that it had been. So, okay, this is helpful.
And to clean that up, Your Honor, the plan and the related documents was filed on May 16th. The plan is a docket number 168, the disclosure statement at 169, and the disclosure statement motion at 170.
Thank you. Okay, that's very helpful. So then now let's go through the docket.
Okay, the first item for today is Guggenheim's retention application, which, again, is item number 3 on the agenda and can be found at docket number 103. We've worked with Mr. Shepard-Carter in the U.S. Trustee's Office to resolve comments to the application and filed the proposed order under certification of counsel at docket number 173. To highlight some of the changes to address Mr. Shepard-Carter's comments, those include language providing that the fees paid to Guggenheim by the debtors during the cases are subject to disgorgement until approved on a final basis, that none of the fees paid to Guggenheim shall constitute a bonus or fee enhancement, that the engagement letter does not waive any fiduciary duties under applicable law owed by Guggenheim to the debtors, and that Guggenheim has no agreement to share any compensation received by the debtors during the Chapter 11 cases, unless otherwise permitted by the Bankruptcy Code. A declaration from Morgan Sacco of Guggenheim is attached to the application as Exhibit B. Following discussions again with the U.S. Trustee's Office, we submitted a supplemental declaration in support of the application, which was filed at docket number 145 and includes further disclosure on the relationship between Guggenheim Securities, which is the entity that would be retained by the debtors, and its affiliates. I would like to offer both of those declarations into evidence.
They're admitted.
Okay. And Mr. Segal is in attendance through Zoom and available to answer any questions. Since Your Honor has questions, I would cede the podium to Guggenheim's counsel from Denton's, who is also present in the courtroom today.
Thank you.
Good afternoon, Your Honor. Thomas Labuda of Denton's,
Yes.
On behalf of Guggenheim Securities. I'm basically here to answer any questions you may have on it. The changes in the order we agreed to with Mr. Shepherd are fairly standard. But if Your Honor has any questions about the terms of engagement, the disclosures, I'm happy to address them.
I have a couple of questions. The first question, I just want to make sure I understand. The monthly fee of $150,000 is 50% of that is credited towards any excess consideration that might be due to Guggenheim, but that's the extent of it. So if there is no excess consideration, then the monthly fees are not credited at all.
That's correct. And that was a change from negotiations that were done prior to the filing. Oftentimes, banker letters are unfortunately renegotiated when the debtor gets close to a filing where parties and interests want to reduce the fees. And it may not be entirely clear from the history, but if you look at the amendment, it actually reduced the fees. The restructuring fee was reduced significantly by $1 million. The sale fee was reduced significantly by $1 million as well. So as a result of that, several other changes were made, including changing to the crediting. Originally, it was just against any transaction fee, but given the significant reductions in the base fees, the crediting was similarly adjusted.
Okay. Okay. Another question I have is with respect to, I guess I say, the priority given to the sale transaction fee, which is,
I think it's paragraph 10 of the order.
yeah, I think it's paragraph 10 of the order.
I can explain the
Okay.
genesis of that.
Okay.
Years ago, there were a couple cases, one being ATP, which was down in Houston, where on the eve of the sale hearing, the lenders terminated the carve-out credit bid and then ultimately didn't agree to an appropriate wind-down budget, and the estate was left stuck with the sale transaction fee because they did go ahead and consummate it after the DIP had been terminated. There was a little pot for post-termination fees, as in many carve-outs, and it was insufficient to pay administrative claims, the case converted. As a result of that, in sale cases, it's become very common, it was just done in this district in Rise Renewables, to basically say if there is a sale transaction, that the banker's transaction fee gets paid, whether the DIP is, the carve-out's terminated or not, that it gets paid from the proceeds. If the lender's credit bidding and there's not sufficient cash component to that bid, that in fact the credit bidder has to pay it. So the benefit of this is really twofold. One, obviously, to the banker to make sure that there are, funds to pay the fee, but it also benefits the estate, and debtors are typically, like this because it makes sure that the secured lender pays the cost of liquidating its collateral and makes sure it doesn't burden the estates of unsecured creditors to pay that transaction fee, which arguably has done very much for the estate and their benefit. So this has become very common in sale cases, not so much in other cases.
I don't think I've seen it. I'm not sure how common it is. It has another aspect to it as well, which, let me see. Yeah, it requires the successful bidder to set aside from its own cash any amount necessary to pay the banker's fees?
Only if there are no cash proceeds of the sale. Where that has come up is in many of the coal cases where oftentimes the consideration is merely the assumption of environmental liabilities and there's no cash proceeds. I don't think that this is that sort of case where there would be no cash proceeds. It would just be an assumption of debt. But that's why that provision is in there.
So doesn't that effectively change the dynamics of the auction?
Well, Your Honor,
Or depress the purchase price?
I'm not sure it does if the cash consideration is at least in excess of the sale fee.
But this doesn't have any assumption in it. I'm just trying to, I have not seen this before.
Sure.
And I don't think this is common. And when I read it, and I may be misunderstanding it, but when I read it, several thoughts came to mind. One, it changes the dynamic of the auction and the purchase price because the purchaser maybe doesn't know, for example, whether or not the estate has sufficient funds to pay the fees. So why would it should assume it will have to pay them and lower its purchase price by that amount. Number two, doesn't that give Guggenheim or any banker an interest now in who the purchaser is? Because it now has a stake. If the purchaser has to pay its fees, doesn't that give the banker some sort of interest in who the successful purchaser is when it shouldn't have one? It should just be concerned about the debtor's interest and not its own about how its fee is going to get paid.
Addressing both of those points, the first one, to be fair, Your Honor, and to be fully transparent here, this provision's in the bid procedures order as well.
I saw it there,
Yeah,
which made me glad that I hadn't just approved this.
Right. Because we do want bidders to be aware of it. And again, I agree, it's certainly not common, especially it doesn't come up in cases where there is, say, a pre-pack or pre-arranged where there's clearly a plan, very certain to be confirmed because a plan has to pay, allowed claim, professional claims in full. On the second point, we really view this more as a carve-out and not really any different than a carve-out. They are basically making sure that it comes from the proceeds of the lender's collateral. I do see your point, Your Honor, that if there is a case where there's no consideration, that could, in theory, then, maybe deter somebody. But they're going to have to make sure that the deal works. Again, I'm not sure what sale would be approved if it's clear the case would be administratively insolvent and there wouldn't be sufficient funds to pay the transaction fee.
I don't know either, but it seems like you're solving then for a problem that you really don't think is going to exist. So why are we solving for it?
Well, there's just uncertainty there. You don't know how the process will turn out. You don't know what the lenders will ultimately agree to or not agree
Probably
to.
nobody in this room knows whether they're going to get paid
That's
or not.
right.
Why does Guggenheim get a special treatment above the debtors professionals or a committee if we had one, or why?
Well, one, it is just the transaction fee that is actually for the work that goes towards directly resulting in the transaction. So it's not their monthly fees, it's not a restructuring fee, it's not anything else, it's just the one fee. But two, again, I come back to what happened in that early case, ATP. It actually hurt the estate that, the credit bidder there didn't have to pay it because the case turned out to be administratively solvent, had to go into Chapter 7. Other professionals, it diluted the carve-out. So it actually does benefit the estate by making sure that the sale takes care of the transaction cost of the sale. Just like other transaction costs, if there were transfer fees or things like this is really, a cost of the transaction, and that's why it should get different treatment.
Where in the code does it say it gets different treatment?
It doesn't. And I agree, if the case did turn out to be administratively insolvent when Your Honor heard final fee applications, there could be, adjustments and things like that made. I certainly understand that. But again, this is something that, we have put in many orders. I could, if it's all helpful, we could compile.
No,
but I assume
it's not, because
yeah.
I don't know if anyone noticed it or if anyone realized what it was going to do, or has this been the subject of some opinion that someone has given?
Clearly not, Your Honor, but it has been discussed, but no opinions.
I haven't heard it discussed. I'd like to hear from the debtors.
Your Honor, Brett Nave of Latham & Watkins on behalf of the debtors. 2 points we would make note here is we see this as really an issue of providing what happens to the fee in the event of a credit bid where there is not a cash component to the bid to pay, to reserve against proceeds of, to pay the transaction fee. And in that scenario, we note that in the carve-out in the cash collateral order, the transaction fee for Guggenheim is included in a carve-out from the lender's collateral. So I think that that mechanism to ensure that the transaction fee is reserved against to have proceeds to pay in the event of that credit bid is something that was already contemplated by the parties and already agreed to by the lenders is coming out of their collateral. And I think the language in their retention order and in the bid procedures is just intended to make that explicit now that we have gone down a path of a sale as opposed to the potential alternative options that we were contemplating when we were negotiating a cash collateral order.
Well, it is explicit because I caught it. But what about this idea that a third-party purchaser should have to pay the fee in the event the estate can't? Nah, I got his perspective. Okay. What's the debtor's perspective on that?
I think we would share Mr. Labuda's comments that if we're looking at a third-party purchaser in this case, we're talking about reserving against the cash proceeds that the estate would receive.
That's not what this says. This says, I don't think it's what it says. Maybe I'm misreading. The successful bidder shall immediately set aside from its own funds an escrow for the exclusive benefit of Guggenheim any amount necessary to pay Guggenheim unpaid portions of the sale transaction fee in full at closing. This doesn't talk about out of the sale proceeds.
You know, Your Honor, one solution to this, because I'm hearing you loud and clear, there's really three parts to this. One is you get paid from the proceeds. Two, if there's a credit bidder, the lenders have to do it. And then the third section, which Your Honor is clearly concerned about, one solution is maybe just to cut out that third part, if that satisfies Your Honor.
Well, yeah, I've never seen that before, and that does concern me. I guess with respect to the credit bidding, it's already been taken care of, and I guess Latham's okay to have Guggenheim get paid ahead of them. So that's how
To be clear, Your Honor, the fee has to be allowed. I don't know that they're really getting paid ahead of them. There is like different treatment, essentially like a carve-out for them, but the fee still has to be allowed. There's really not priority. It's just a different carve-out bucket in essence.
Okay, maybe I didn't pay enough attention to the carve-out and the dip, but okay, I don't know that there's any, well, there is no provision in the code that creates a priority, but I don't hear anybody objecting to it, and but I am not going to approve that third aspect of it. I'm not comfortable with that, or comfortable enough yet to be able to do that. The only other question I have, and I think it also relates to Latham, is the representation of Carlyle, Cogentrix, and other non-debtor affiliated entities and what that engagement was pre-bankruptcy.
Sure, and we did, talking amongst professionals, tried to think what Your Honor might be concerned about, and that did come up. Guggenheim has not been engaged by Cogentrix on anything else. They have done work for Carlyle, which is on Schedule 2. I don't have the details of the individual matters. They clearly are all unrelated to the debtor. We also confirmed that for each of the last 3 years, the revenues for Carlisle matters, not just one entity, but all Carlisle matters, is less than 1%, which is usually a question, we get in these sorts of situations. So I can, state that on the record for Your Honor. If you need a supplemental declaration, we're happy to do it.
No, I don't need a supplemental on that. I was more concerned or more interested in hearing about the engagement pre-bankruptcy. So, make sure. Okay, the Guggenheim was retained by two Cogentrix entities.
But they are debtors in this case, not the non-debtor affiliate.
Okay, thank you.
Okay.
Then that,
So we can submit a revised form of order deleting that.
Please.
section, Your Honor. Thank you.
and when I get that, I will sign it.
Thanks.
Thank you.
Good afternoon, Your Honor. Caroline Reckler on behalf of the debtors. Your Honor, next on the agenda is the Latham & Watkins retention application, and I'm happy to jump to your question that you just raised in connection with the Guggenheim application, or start wherever Your Honor wants. I do also want to note that my partner, George Davis, who was the declarant, is on the Zoom in case you have questions for him in addition to me.
Yeah, let's start with that.
Yes, Your Honor. In paragraph 7 of the Davis Declaration addresses Your Honor's question. My firm has represented Carlisle and Cogentrix going back to 2017 with respect to this situation. We, in fact, represented them in the acquisition of these assets. Starting in, and I tried to figure out the date this morning, it was either late January of this year or early February, as we moved towards a restructuring or began those discussions. We ended the relationship with respect to this matter for Carlisle and Cogentrix, and Carlisle has its own counsel engaged in this matter.
Okay, and does Latham have a waiver from Carlisle Group, if necessary, to be able to take any position the debtor may need to take against Carlisle?
Your Honor, in that situation, it would be our colleagues at Young Conway would handle the actual adversity with Carlisle if it came to that. And I'll give you an example of that that's already happened, Your Honor, in connection with the plan, and it's premature today, but you will see there are releases in that plan. And Young Conway and our independent director investigated whether that was appropriate or not, and my firm had nothing to do with that. So that's one example where we have already called upon Young Conway to handle what could even be perceived as a conflict.
Okay. Okay, that was the big question that I had with respect to Latham's retention. And so I understand that Young Conway will be representing the debtor to the extent that it needs to be, and apparently it's already been used once in connection with any issues with Carlisle. Okay, so with that, I will approve the retention as it was submitted.
Okay, thank you, Your Honor.
Thank you.
I will turn the lectern back over to Mr. Nave for the next two matters. Thank you.
For the record, Your Honor, Brett Nave on behalf of Latham & Watkins on behalf of the debtors. The next item on the agenda is FTI's retention application, and that can be found at docket number 106. We've also worked with the U.S. Trustee's Office to resolve all comments on that application and form of order, and the proposed form of order was filed under certification of counsel at docket number 175. Mr. Pugh, the company's Chief Restructuring Officer of FTI, filed a declaration in support of that application and is present in the courtroom, I'd move that declaration into evidence, and Mr. Pugh is present and able to answer questions, as am I.
Thank you. That's admitted. Okay, I think actually it's the same question with FTI.
Related to the
Related
Carlisle
to
Cogentrix.
its representations of Carlisle Group.
Correct. Okay. FTI has represented Cogentrix Energy Power Management in unrelated matters to this on other project assets in the past and currently. There was no involvement with respect to this matter prior to being engaged by the debtors to serve as Chief Restructuring Officer.
Okay, thank you. That was the question that I had with respect to that, so I will also approve the FTI engagement.
Thank you, Your Honor. The next item on the agenda is number 6. It's the bidding procedures motion, which can be found at docket number 131. And then a certification of counsel was filed at docket number 178. We have Ophir Nitzan from Guggenheim in the courtroom today, who is available to provide evidentiary support for the motion and also answer any questions regarding the sale process or bid procedures set forth in the motion. I'd also be happy to walk through the red line changes or answer any specific questions Your Honor has. And before turning to that, I just note that the change we discussed with respect to the language in Guggenheim's retention order, the debtors would obviously be, of course, willing to make to the similar language within the bid procedures order as well.
I don't think I have. A declaration.
That's correct, Your Honor.
Okay. So I'd like a basis to know that the procedures set forth and the timeline that's set forth in the motion is appropriate and that the marketing will be fulsome and sufficient.
Understood, Your Honor. I'll turn the podium over to my colleague, Christopher Harris, who will be able to put Mr. Nitzan to provide evidence of support of that.
Good afternoon, Your Honor.
Good afternoon.
It's Chris Harris of Latham for the debtors, and we call Ofer Nitzan of Guggenheim as our witness.
Good afternoon.
Good afternoon. Can you please stand, please? We need to swear you in.
Ophir Nitzan, N-I-T-Z-A-N. I do.
Good afternoon. Could you please just briefly describe your educational history to the court?
Yes, I graduated from the University of Connecticut with honors with a bachelor degree. I also obtained a master's of business administration from NYU Stern School of Business, graduating with honors. I have a certified public accounting certification, and I hold Series 763 and 79 licenses.
And where are you currently employed?
I'm employed by Guggenheim Securities.
And what's your position there?
I'm a managing director
And how long have you worked at Guggenheim?
since 2012.
Can you just briefly describe your professional experience before joining Guggenheim?
Yes, after graduating college, I worked at KPMG for 3 years. I then worked for a private equity fund for 7 years, most recently as a chief financial officer. I then worked at Bear Stearns from 2007 to 2008. I then worked in the restructuring group of Miller Buckfire from 2008 to 2011. And I was recruited in 2012 to join Guggenheim to help start the restructuring and liability management group.
And how many asset sales have you been involved with in your career?
I've been involved in numerous asset sales, both as an investor and an advisor.
And do you have any prior experience in the power generation industry?
I do. I have. I've been involved in numerous power-related transactions. For example, I was involved in the restructurings of Homer City, First Energy Solutions, Energy Future Holdings, and GenOn Remo.
And then focusing on the debtors here, what's Guggenheim's role with respect to the debtors?
Guggenheim is the proposed investment banker to the debtors.
Okay, and when was Guggenheim engaged?
In February 2023.
And what's your personal role on the Guggenheim engagement?
I lead the Guggenheim engagement from a restructuring perspective together with some of other senior members of my team. I also work very closely with senior members of the Guggenheim Power and Utilities team who have intimate knowledge of the debtors' assets.
Okay, and based on your role with Guggenheim and with the debtors, have you become knowledgeable with the debtors' assets and the sale process?
Yes.
Okay. And are you familiar with the bid procedures motion that's before the court today?
Yes.
And in particular, are you familiar with the sale process that's outlined in it?
Yes.
And just to back up, why are the debtors pursuing a sale process?
The debtors have explored numerous restructuring alternatives and have determined that exploring a sale process would be in the best interest of the estate.
Okay. And what assets are being marketed?
All of the debtors' assets are being marketed.
Okay, so can you describe, again, at a high level, what marketing has occurred already?
Yes, Guggenheim started marketing the assets in April 2023. We have reached out to more than 25 potential buyers. We have provided them with confidentiality agreements. More than 15 parties have signed a confidentiality agreement, and we provided them then with additional marketing materials on the debtors in the form of a confidential information memorandum. We have informed them that the indications of interest were due on May 10th. On or about May 10th, we have received numerous indications of interest. We have provided the parties that provided indications of interest with access to the data room that contains additional information on the debtors. We held calls with each of those bidders to answer any questions and walk them through the proposed milestones in the bid procedures. We also send them copies of the bid procedures. And we have scheduled site visits at this point and informed them of the bid deadline.
Okay. And just to be clear, is the marketing process over?
The marketing process is ongoing.
Okay. And we can pull up the bid procedures motion if it's helpful. I just want to kind of walk the court through the dates that remain, but if it's helpful, we can display it on the screen. You have it in front of you and the court has it in front of you. I'm not sure if you have them memorized. So
I believe that I memorized the dates.
Okay.
The indications of interest were due on May 10th. On June 9th is the notification deadline for a stalking horse bids. June 20th is the bid deadline, and June 26th is the date of the auction if one is necessary.
All right. So based on your experience as a banker and your knowledge of these assets, do you believe the bid procedures will facilitate a value maximizing sale of those assets?
Yes, I do believe that the bid procedures will permit the debtors to solicit and obtain the highest and best bid.
And again, based on your experience, does this schedule provide parties with enough time to evaluate the assets and formulate a bid?
Yes, based on my experience, it does. My view is also based on conversations I've had with my colleagues in the power and utilities group at Guggenheim who are intimately familiar with these assets, as well as with the buyer universe, and their view is that the timeline is sufficient for the debtors to solicit and obtain the highest and best bid. We have also had discussions at this point with interested parties and with the actual bidders, and none has suggested that the timeline was too condensed for them to not provide a bid or to not put their best foot forward.
And now let's talk about the bids themselves. Are the bidders required to make a good faith deposit?
Yes, the bidder is required to make a 10% deposit, 10% of the total purchase price.
Okay. And based on your experience, is a 10% good faith deposit a reasonable balance between encouraging bidding but also reducing completion risk?
Yes, that amount is reasonable, and I think does provide and strike a good balance between not deterring bidders from participating and providing the debtors with mitigating some of the completion risk. Again, the bid procedures have been provided to the bidders, and nobody has raised this as an issue.
And are the debtors seeking approval of a stalking horse bid at this time?
No, the debtors are not seeking approval of the stalking horse today.
Okay. Are the debtors preserving the option to seek approval of one?
The debtors are requesting the option for the stalking horse to the extent that the debtors identify a stalking horse and execute a stalking horse agreement, which means they believe it provides value to the estate and a potential to maximize value. Then they're seeking the court to approve the stalking horse to the extent that there's no objection. To the extent that there is objection, the debtors will be back in front of the court.
And if you do seek approval of a stalking horse, would the bid procedures contemplate the ability to seek bid protections for the stalking horse bidder?
Yes.
And if we're in that situation, in your experience, would bid protections be appropriate for a stalking horse bidder?
Yes, bid protections are customary for a stalking horse bid. Sitting here today, the debtors have not designated a stalking horse bid, but those protections are customary.
And so, stepping back, based on your experience, do you believe that approval of the bid procedures is in the best interest of the estate and would be value maximizing?
It is.
We have no further questions, but the witness is here for your honor.
Thank you. You may step down.
I'm also happy to answer any questions. For the record, this is Brett Nave of Latham & Watkins on behalf of the debtors. I'm also happy to answer any questions on the procedures or the form of order. There is one additional change that hasn't made it into a red line yet that was discussed with the parties this morning as we were walking in that I wanted to make Your Honor aware of and note for the record as we would propose to include in a final form of order following the hearing. And that appears at I'm looking at the red line now, page 10 of the bid procedures, where we say that no later than 1 day prior to the start of the auction, the debtors will notify each qualified bidder whether their bid is a qualified bid, and then provide each qualified bidder with a copy of each qualified bid. I think that was an oversight and frankly inconsistent with the idea that what we would be sharing is the baseline bid that's the highest at the start of the auction, and going from there, not each and every
Not
bid
all of them.
received.
Okay. Okay. I do have some questions on the form of order. We'll get to it, but I will approve the bid procedures order based on the testimony that was just received, which justifies the timeline and the process itself, the testimony being that it is sufficient to run a process, maximize the value, and permit the participants and potential bidders sufficient time to put forth their bids. So I will approve it. But let me take a look. Let's take a look at the order, and I am looking at the hope I'm looking at the black line. So. I have I'm on page, page 5, and I'm in the box here with the timeline. And the June 9th date for assigned contract, the assigned contract objection deadline. It wasn't clear to me if that is just for cure amounts or if you expect general objections there as well. And how that dovetails with the post-auction objection deadline.
I think what we would expect at that deadline is cure amounts as scheduled, and if there are any objections to the ability to assume or assign a contract, such as, X, Y, or Z contract is just not assignable, and therefore I object. I think the post-auction objection deadline does contemplate that when the identity of a successful bidder is known, if there's adequate assurance of future performance type objections, or obviously changes to the cure amounts based on discussions with a bidder, those kind of items would be fair game for an objection in the post-auction objection deadline.
Okay. Well, that's what I assumed. It wasn't totally clear to me, but since you have that understanding, then I'm fine with it. You have a defined term in paragraph 5, the consultation parties. Is that just the lenders as?
That's correct. It's the collateral agent under the security agreement, which is the entity that would be submitting a credit bid if one is submitted.
Okay, and I think it's in a footnote, maybe in the bid procedures where I saw that. How does that work? When do the lenders have to determine whether they're going to be part of the process or not?
Yes, Your Honor. The way I think the debtors envision this working is that we will receive committed bids by the bid deadline, and that, we would like to have this conversation as early as possible, but at minimum by that point we'll have a conversation with our lenders around the bids received, the terms of the bids received. Do they clear a lender reserve price? And if the answer to that is yes, then I don't think there's any requirement that, and we would not be seeking a requirement that they waive the right to credit bid at an auction or be our default bidder under the plan as currently constructed. But I think going into an auction in that scenario, we would consider them not to be a bidder and would be a consultation party. If at that committed bid deadline they're either unsure or does not cross the reserve price, then I think at that point they would be more likely to be considered by us an active participant and an active bidder in the process, and those consultation rights would fall away. And of course, to the extent they formally submit at the bid deadline at the auction at whatever point a credit bid, in that scenario, I think it would be clearly would be a capital B bidder and not a consultation party.
Okay, well, I agree with you, except more strongly, that if the lenders are unsure about whether they're going to credit bid after they see the initial bids that have been provided, then they are not a consultation party after that. They are a bidder. If they know they're not going to, if it meets their reserve price and they're not going to bid, fine, then they can be a consultation party. Otherwise, they are not a consultation party at that point.
Understood.
I didn't understand paragraph 6. I just must be reading it wrong. If the debtors do not receive one or more qualified bids, the debtor may cancel the auction. The only qualified bid will be deemed to be the successful bid. What bid is that? If I'm not getting that.
I think that's addressing the situation where it's the or more qualified bids. So if we receive one qualified bid but only one qualified bid, then we would deem that to be our successful bid. I think we could
More
probably,
than one, not one or more. More than one?
Yes. Yes.
Okay.
Yeah, we'll make that change.
Okay.
Avoid any doubt about that point.
Okay. In paragraph 10, the collateral agent shall have the right to credit bid within the meaning of 363. Where does the challenge period fall in connection with credit bid rights?
June 18th is the challenge period, and our bid deadline and auction fall beyond that date.
So I'm not going to prejudge whether they can credit bid when the challenge period is open. So this needs to be made subject to the challenge period or subject to the end of the challenge period without a challenge being made.
I think making it subject to the challenge period or subject to the challenge period with no challenge being made is acceptable to the debtors, certainly.
Okay. Okay, in paragraph, what's now 19, I'm fine with the debtor supplementing its list of assigned contracts and removing assigned contracts from the list as long as that removal is prior to closing and the assumption. Believe it or not, I had this issue come up very recently where after assumption and assignment of a contract, the purchaser said its procedures gave it the right to remove a contract. I don't view that as what you're trying to do here, but let's make it clear that it's prior to closing with that contract having been assumed. Otherwise, it should be left open and not close with it. And you can have it open until you decide whether you're assuming or rejecting it.
Sarah, I think looking at the second sentence in paragraph, what is now 19, where it says, accordingly, the debtors have the right at any time after the service of the assignment motion or notice, and before closing of a sale. I think that caveats
right.
all of those.
You're right. Thank you. Yes? Okay, thank you. And then in paragraph 20, if there's a supplemental assignment notice, parties shall have 10 days from the service of the notice. Not the date of it, but the service of it.
Yes, Your Honor, we'll make that change.
Okay. Paragraph 22, and again, I'm just trying to understand the relationship between the auction, confirmation. This says if the auction occurs after the confirmation objection deadline, post-auction objections may be filed with the court. I'm not sure. I don't understand the interplay.
I think the intention, Your Honor, was to have the objection deadline be the same as the confirmation objection deadline, which has not been set yet, but would be later in time than, I believe, as we're proposing even our auction. Yes, our confirmation objection deadline is currently proposed for July 21st with our auction of June 26th. So I think our sale, because our sale is so intimately tied to the plan, we had proposed to make the confirmation objection deadline the deadline to put out any objections to the plan that includes the sale that's contemplated thereby. But if the auction, for whatever reason, were delayed such that it fell after our confirmation objection deadline, in that case, we wanted to provide for that contingency that there is the 3-day period to object.
So this is giving contract parties longer.
I think in the only circumstances operates is to give them longer.
Okay. Okay. Those were my questions and comments. And so I'm prepared to sign a bid procedures order that conforms with the discussion that we've had.
Okay, great, Your Honor. We'll submit that revised order from order after the hearing.
Okay.
The final item on the agenda is the PJM settlement motion, and I'll hand the lectern over to my colleague Caroline Reckler to handle that.
Thank you.
Good afternoon again, Your Honor. Caroline Reckler on behalf of the debtors. Your Honor, just as a matter of good housekeeping, I believe I forgot to move the Davis Declaration into evidence in connection with the Latham retention that was agenda item 4.
Okay, that's admitted.
Thank you, Your Honor. Your Honor, I think this brings us to the final item on the agenda. That's agenda item number 7, and that's the PJM settlement motion. That can be found at docket number 137. We also filed a declaration of Mr. Pugh in support of that motion, and that declaration can be found at docket number 138. We also filed a certificate of no objection at docket number 179. We did have conversations with Mr. Shepard Carter after the filing of the motion and believe we've addressed all of his questions. Your Honor, I previewed at the first day hearing that the debtors were prepared to commence an adversary proceeding, and in fact, we had the papers ready to go, and that would have been both a complaint and a summary judgment motion. I think we've made very good use of the last 6 or 8 weeks or so resolving that litigation without the need to bring it to Your Honor. I'm happy to walk through what that litigation looked like and the benefits to the estate. I can say that it enjoys the support of both the lenders and the debtor, in addition to PJM. I think there were compromises and settlements made on all sides, and that settlement really helps us to achieve the main objective of this case, which is to maximize the value of the assets either through the sale process that you heard Mr. Nitzan address in his testimony, or depending on the results of the third-party buyer interest, those assets could be transferred to our lenders as well. But I think what the settlement primarily does is it brings clarity and certainty to our sale process and to any buyer going forward, and that it allows them to move forward without the overhang of the PJM alleged penalties, and it also allows them to move forward with certainty, knowing that they will be able to operate the asset going forward. There's certainly FERC and other approvals that will be required, but PJM will be supporting this bankruptcy process moving forward, and we don't expect any anticipated obstacles related to the penalties as a buyer applies for the necessary approvals to operate the asset.
I have a better feel for this now. The big questions that I have with respect to the settlement was sort of the timing of it, and what happens if I approve it today and then, for example, there wasn't a sale, or maybe what if we don't have a confirmed plan? What's the impact of approving this today in those kinds of circumstances? Because the settlement is taking effect today.
That's right, Your Honor, and there are certain parts of this that would be, for example, the amount of any allowed claim for PJM. If I don't know what could happen if, I don't know, I guess the third alternative, there are two alternatives that come to mind. One would be a dismissal of these cases or a Chapter 7 if we don't sell the assets or confirm a plan. In that case, the amount of the allowed claim would be locked in for PJM. There are also certain releases that the debtor is providing that would be locked in today, and we spent a lot of time thinking about questions Your Honor could have about those releases. First and foremost, we are not in any way looking to shorten or modify or in any way adjust the challenge period that others have with respect to our lenders in the cash collateral order, and they've confirmed that. With respect to the release that the debtor would be providing of PJM, again, it would be related to these penalties. It would not be related to any conduct before the penalties arose or related to the restructuring. Those would be effective upon consummation of a plan if and when we get there, which we hope we will.
Okay. As I said, one of the reasons I didn't do everything under CNO or COC was because I had questions about how all of the debtors' the motions fit together with the bigger small p plan for this case, and also because I don't have a committee to have vetted all of this. There's a question in my mind based on reading the motion, and I do have the declaration short, but it supports the settlement, and I understand the issues with respect to PJM and their ability to assert claims that could create issues with respect to the ability to operate the assets on a go forward basis, and quite frankly, the need for their cooperation for any prospective purchaser to be able to run the assets in the ordinary course, regardless of the penalty situation. So I don't have any questions that this settlement is above the lowest rung on the ladder of potential settlements with respect to the disputes that the debtors previewed in the first day and that are described in the motion. I do recognize, and I was focused on, again, what happens, what relief is being given today that could prove in circumstances that nobody's really contemplating, but could prove to be problematic if these the debtors' cases do not come to some sort of successful conclusion. There are, as counsel has explained, certain pieces of the settlement that are being locked in today, but the settlement was negotiated at arm's length. I have a declaration supporting it, and I have no opposition to it. So I will approve the settlement as submitted, and I appreciate the discussion.
Thank you, Your Honor.
I don't think I had any questions on this order. Let me just double check. I have no questions or concerns with respect to the order. Okay.
Thank you, Your Honor, for your time today.
Thank you. I guess I just want to double check because I don't have my calendar out here. Do we have these dates on my calendar? The June 20-something?
21st, I believe.
June 21st, and then July something, 23rd?
26th, I believe.
26th. Okay. Thank you.
Thank you, Your Honor.
Thank you. We're adjourned.